After 30 years inside federal courtrooms, you stop being surprised by verdicts. You've seen too many of them. Guilty, not guilty. Hung juries, appeals. Those moments make headlines. But they are not when a case truly ends. The real ending happens much earlier. Long before a judge speaks or a jury files back into the room, it happens in a quiet moment, away from cameras, when the defendant realizes something irreversible has occurred. Not a leak, not a rumor, not a hostile witness, but a handoff from inside their own circle. That is the moment when the air changes in the room, when strategy collapses into calculation, and this morning, all indications suggest we have reached that moment in this case. What we are seeing now is not just a shift in testimony or legal arguments. It is a shift in evidence itself, specifically physical, digital evidence that did not come from an opponent or an outside investigator, but from within the family. When a daughter, a son-in-law, or a trusted advisor hands over a hard drive, the entire defense posture changes instantly. I've watched it happen many times. The defendant doesn't panic. They don't explode. They freeze. Not out of fear, but because they understand exactly what that device contains. They know what they opened, what they moved, what they deleted, and what they believed no one else would ever see. I've built cases against war criminals and deeply entrenched corruption. Those defendants always prepare for witnesses who might turn. They brace for media leaks and hostile press. What they never prepare for is the silence of a hard drive, a device that does not argue, does not forget, and does not reinterpret events after the fact. A device that records every action, every timestamp, and every decision without emotion or loyalty. That is why this moment matters. That is why this turnover changes the trajectory of the entire federal case. In the coming weeks, I'll walk you through what this evidence actually means, how digital forensics dismantles traditional defenses, and why this specific development closes doors the defense was counting on keeping open. I focus on evidence, not spin. And if you want to follow this case without the noise, now is the time to pay attention. Because once we strip away the headlines, what's left is forensics. And forensics are unforgiving. When people hear the phrase hidden hard drive, it sounds cinematic, like something pulled from a spy thriller. But in a federal investigation, a hard drive is not dramatic. It is procedural, it is methodical, and it is extraordinarily dangerous for a defendant. A hard drive represents a digital chain of custody, one that often speaks louder than any witness ever could. Witnesses are human. They forget, they reinterpret, they hedge. A witness can say, "I don't recall," or "That wasn't my understanding at the time." Jurors may accept that. They may believe the chaos of the moment excuses uncertainty. But a hard drive does not forget. When prosecutors subpoena a device from someone inside the inner circle, they are not simply searching for emails or messages. They are examining metadata, system logs, and invisible records that most people never think about. Every file interaction leaves a trace. Opening a document, moving it, renaming it, or deleting it all create digital fingerprints. If a defendant claims ignorance, but the hard drive shows access at a precise time on a precise day, that defense disappears instantly. This is why cooperation from a family member carries such weight. It is not about what they say. It is about what they surrender, and what that surrender reveals. And once that device is in government hands, the story no longer depends on memory. It depends on math, time, and code, which brings us directly to the next stage of this unraveling. When an advisor or family member turns over their communications, they are not just handing prosecutors files. They are handing them a map, a detailed record of who spoke to whom, when they spoke, and what actions followed those conversations. This is what we call corroborative forensics, and it is the backbone of modern federal prosecutions. It means the government no longer has to rely on trust. The device itself verifies the narrative. If a witness says, "He instructed me to move the boxes," and a time-stamped message confirms that instruction minutes later, the case transforms instantly. It stops being a dispute of stories and becomes a matter of proof. This is why the defense strategy we've seen so far, delay, deflect, and deny, is now running into something immovable. You can postpone hearings, you can challenge filings, you can stall a trial, but you cannot delay a timestamp. Time exists independently of legal strategy. A digital record does not care how many motions you file. It remains fixed, precise, and intact. Naturally, people ask the same question every time this happens. Why would a daughter, a son-in-law, or a trusted insider turn over material that could be so damaging? Is it betrayal? Is it ideology? Is it politics? After 3 decades of prosecutions, I can tell you the answer is almost never emotional. It is practical. It is self-preservation. This is the part of the federal system that television glosses over. When a special counsel investigation targets a high-profile figure, the pressure does not stop with that individual. It spreads outward. Advisors and family members quickly stop being passive witnesses and start becoming subjects. They hire their own attorneys, and those attorneys have one obligation only: to protect their client, not the powerful figure they are connected to. I've sat across from these lawyers many times. The conversation is always direct. We explain what we have: the documents, the logs, the records, and then we lay out the reality. Your client has 2 options. They can sit in the defendant's chair, or they can sit in the witness chair. There are no other seats available. This is the prisoner's dilemma in its purest form. When loyalty begins to threaten freedom, loyalty collapses. Protecting the central figure often means risking prison, financial ruin, and permanent reputational damage. At that moment, allegiance ends. This isn't betrayal. It's inevitability. The government does not need everyone to cooperate. It only needs the one person with access, the one who managed communications, the one who held the passwords. Once that person decides to save themselves, the wall of silence breaks. And now, that break has occurred. Which brings us to the most critical concept in this entire case, the one element that causes the freeze I described earlier. That word is intent. In cases involving obstruction or mishandling of sensitive information, proving that something happened is rarely difficult. Boxes moved. Documents existed. Files were relocated. Those are physical acts, and they can usually be established through video, testimony, or basic records. The real challenge for prosecutors is proving intent, showing not just that an action occurred, but that the defendant understood it was illegal and chose to proceed anyway. Without internal communications, intent is hard to lock down. The defense can argue confusion, distraction, delegation. They can claim the defendant was busy, misinformed, or unaware. That ignorance defense is powerful because it introduces reasonable doubt. It gives jurors a place to pause, but internal communications erase that pause. When a hard drive reveals emails or messages discussing how to hide documents, how to move materials out of view, or how to delete footage, ignorance becomes impossible to argue. You cannot claim you didn't understand a plan you actively discussed. This is why cooperation from the inner circle is the checkmate move. It provides the why behind the what. Now imagine the moment defense counsel learns that this drive has been surrendered. They immediately have to assume the worst. That every conversation they believed was private may now be evidence. That every instruction could be reconstructed. That every timeline they intended to challenge may already be confirmed. This is what creates legal paralysis. They can no longer safely advance arguments without risking contradiction by the data. They cannot claim one sequence of events if the metadata proves another. They cannot put the defendant on the stand to deny actions if the digital trail confirms them. Their strategic options collapse. This is not emotional shock. It is strategic suffocation. The chessboard shrinks until there are no safe moves left. For defendants accustomed to controlling narratives, this is the most destabilizing development possible. You can debate prosecutors. You can challenge judges, but you cannot argue with your own encrypted messages. The evidence forms a box, and once sealed, there is no exit. And that leads to the larger question. Why does this matter beyond one defendant and one case? It matters because this is how the justice system is designed to function. We hear constant claims that powerful people escape accountability, that delays equal immunity, and that status bends the law. That frustration is understandable. But evidence is the great equalizer. Digital forensics does not care about titles or influence. A deleted file is the same whether it belongs to a president or a private citizen. What we are witnessing is not spectacle. It is process. Slow, deliberate, and methodical. When courts accept this evidence and grand juries review these records, they are reaffirming a core principle. No one is above the law. If the system allowed power alone to shield evidence, it would collapse entirely. Instead, we are seeing subpoenas enforced, privilege claims challenged, and evidence preserved. This is what accountability actually looks like. Not speeches, not rallies, not press conferences, but hard drives, timestamps, and authenticated records presented to jurors. This phase marks a transition. Political rhetoric is giving way to legal specificity. The surrender of this drive signals deeper movement into the inner circle. We should expect motions to suppress, challenges to chain of custody, and renewed delay efforts. But the evidence is now preserved, logged, secured. It cannot be undone. That is not a threat. It is not a promise. It is simply the mechanics of justice. Truth tends to surface quietly, through data, rather than declarations. And as we move forward, the noise will increase, but the facts will remain unchanged. Every major case reaches a point where public arguments stop mattering. This is that point. The defense can still speak loudly, but volume does not alter metadata. The narrative may continue to shift, but the timeline does not. Once digital evidence enters the record, the case moves onto rails. This is why seasoned investigators focus less on statements and more on systems. Systems record behavior without bias. They document intent without emotion. They show patterns, not just moments. And patterns are what juries understand. What we are seeing now is the system doing exactly what it was built to do. Not quickly, not dramatically, but thoroughly. And that thoroughness is what makes it credible. As more filings appear and more evidence becomes public, remember this moment. The quiet handoff. The device that spoke without words. Because long after the arguments fade, the record will remain. Justice does not announce itself with spectacle. It arrives through procedure, through logs, through verified records, through the slow accumulation of facts that eventually leave no room for doubt. If you want to understand how this unfolds beyond the headlines, follow the evidence. That is where the truth lives. And right now, the truth is being reconstructed, byte by byte, from the silence of a hard drive. I'll continue to break this down as it develops, focusing on facts, not theatrics. Let me know what this evidence means to you, and whether you trust the process to handle it fairly. I read every response, because in the end, the system relies on one thing only: truth. And today, we are closer to seeing it clearly.